Hey guys, welcome back. This is part three. It's Dark Angel here. Hey, so I just want to thank all my haters, traders, and uh, trolls. You guys are great. We had some pretty interesting conversations over the weekend, and the weekend just getting started. But we've had some pretty good, pretty interesting little interactions going on. And once again, you haters, traders, and trolls failed to prove or disprove anything that I've been saying. I've actually had one guy get on here and actually swear up and down that he's had people tear this whole thing apart. And I told him, I said, well, send him over here to my channel, and we'll see just how much tearing apart he can do, because I've never met one person that can actually provide any type of proof that would show that this is not real. They haven't provided one case law. They haven't even provided a legitimate argument other than their opinion. And as we all know, everybody has assholes, so everybody has an opinion. But the thing is whether or not that opinion carries more weight than what a handful of crap does. So, it's like I tell them, crap in one hand, put your opinion in the other hand and see which one outweighs the other one. And then see which one smells like a bunch of crap. You understand? So they're not grasping that concept. But this is coming from highly intelligent people who think they know everything when they don't know their assholes from a hole in the ground. So there's that. So anyway, this is part three of One Country, Two Jurisdictions. And you know what? Instead of sitting here doing all the talking and all that, I'm going to go ahead and get right off into it, because I want to cover quite a bit today without actually trying to throw a lot of my personal emphasis into it. Okay, so I want to just go ahead and get off into it and see how far we can get today. So today we're going to go ahead and cover. I had planned on covering uh, the parts about contract, but being that it was sporadic in formation, I actually have another section about the contract that will actually go into a little bit more in-depth detail about the contracts between you and the government, etc., etc. So basically, what I'm going to do is I'm going to get into uh, I'm gonna just go right into title and registration of the automobiles, okay? Because I feel that that's a little bit more important than insurance. Because as a private owner of an automobile and not having your automobile registered, you can still purchase if you feel that you owe an obligation. Okay, you can still purchase insurance for that private automobile without it being registered. There is insurance companies out there, as you all must know by now. Insurance companies are private. Okay, they're independent insurance companies. So, you know, and they're government operated, but not governmentally owned. So, you know, but you also got to keep in mind too that every man is independent of all laws except those prescribed by nature. He is not bound by any institutions. That means insurance agencies, corporations, etc., etc., formed by his fellow man without his consent. Okay, and if you remember in part two, I was elaborating on that, about that if you didn't give consent, it don't apply to you because you are independent. Okay, you got to remember you're independent of all laws in the free republic states, okay, of America. Okay, now under the corporate, and you're registered, you're licensed, etc., etc., then you have to follow by corporate standard laws. You have to follow their laws, and their laws do say that you're required to have insurance, liability insurance, just to do this, do that, do this. But see, per the law, okay, per the law that's laid down by the Supreme Court, all men are independent of laws. See, so you got to understand common law, corporate law, two different jurisdictions, two different sections. So anyway, but like I said, you can still do that. So under title and registrations, the motor vehicle title is a document used by the DMV commercial corporate to identify the commercial vehicle to be registered and the business registering it. Without a title, the motor vehicle cannot be used for commercial purposes on the road. Have you noticed the statement on the title, certificate of title, motor vehicle? The USC Title 18 defined motor vehicle is a commercial vehicle used for profit. The only purpose of the title is to register the motor vehicle for commercial purposes. Now, if the DMV refuses to title a vehicle for commercial purposes, then it cannot be used. But this does not mean that it can't be driven as an unregistered automobile for private use. So basically what it's saying there, real just quick in hand, is saying that if they refuse to title it as a commercial motor vehicle, then it can still be used as an unregistered private automobile, because one, there's no law saying that it can't. So again, back to the very beginning of when I've started all this, if you remember what I told you, where there's no statute, no policy written, no law can be enforced. Point blank and simple, bottom line, people. There is no statute or policy that's ever been written about private motor vehicles. So therefore, you can't enforce a law on something that doesn't exist. Point blank and simple. Just that easy. So, yeah, but you'll get a lot of resistance. But like I told you, this is a business. So the United States is not trying to lose money. They lose money when you unregister your motor vehicle. So you got to understand that. And if you don't care about that, you'd rather go ahead and give them the money, then go ahead and give them your hard-earned money. I'd find it absurd to do such a thing, but hey, that's me. Let's see. Let's go back over here for a second. So yeah, a minute. Okay, so anyway, let me go back because I skipped the whole little part here. Let's see. Unregistered automobile. Okay, for private use. Okay, the automobile is protected by the Fourth Amendment. Okay, household effects. The commercial is not. Well, there you go. See, commercial is not. So registering your automobile as a commercial allows it to be impounded when violating DMV contract. Otherwise, it is being stolen, taken without a warrant, if it is unregistered when used for private use. Simple. See, just like they can sit there and sue you for stealing an automobile, you could turn around and sue them. There is no, and for those of you who think that there is no immunity for that. Okay, what it is you getting up off your lazy ass and taking your ass down there and file a lawsuit. That's what it's all about, filing the charges, calling the sheriff and having charges filed. A lot of people think that, oh, once they take it and impound it, that's it, and then I'll have to do this and do that. No, what you got to do is take, because you are on the private side, your automobile is your personal private property. The highways, you have to remember, the highways was made for private travel. Okay, you need to discern the difference between private travel and extraordinary use. Extraordinary use is the commercial activity, the commerce that's going on. That is what the state is allowed to regulate. The state has been given permission over the decades, over the years, to regulate its commerce, the travel of commercial activity, not the use of private automobiles on the highways. Never has the state been given that authority to do that. And for those of you that don't know that and don't know how to read law, you need to get in there and read the law. And I promise you, you will never find one case law that says that the state has the right to regulate private travel. I promise you that. Now you guys come in there with that Hendricks versus Maryland bull crap again, talking about, well, it says all vehicles. When it talks about all vehicles, motor vehicles, okay, and automobiles, it is talking about every automobile and motor vehicle that is traveling in commerce. That's what that case is about. That's why that case has never been used against us in an argument ever, because it's commercial. Duh. Every single case that's ever been produced by the Supreme Court in reference to activity on the highways is commercially related. Okay? So you need to get that in your heads and quit trying to put commercial activity over to the private side, because there is none. There is no statute or policy governing the private side. Okay? No state has jurisdiction over anyone riding on the private side. It's even in the Constitution. Okay? No state shall have precedence over that of persons' private affairs. So before you go running off at your mouth trying to come up on here making these old comments and all that, you need to know your Constitution. You need to know the whole law as a whole instead of parts of the law that you think will work for what you're trying to stress, because the entire law that you have to put links together to link everything together to make one complete circle, okay, doesn't only work in fragments. This is not a geographical pie that you can only have so much percentage of the circle done to make a whole. That's not how it works. You either have 4 quarters, 50% and 50% makes a whole. 4 quarters makes a whole. So, but the point is you need to know the whole thing before you sit there and try to argue anything. So, with that being said, a title is useless to the private owner because they are not required to register their privately owned automobile. Again, there it is right there in writing. It is not required when sold to another private owner either. Yeah, I bought a BMW, didn't have a title to it. Matter of fact, the title had a lien on it from somewhere, some bank. But I bought the automobile, and I bought a bonded title, put $3,000 bond on it, right? I had the car for 2.5 years, and not once has the bond ever been challenged. You understand? So when I sold that vehicle to a young lady, okay, it had a $3,000 bond on the title, which we never saw. Okay, and she was in the clear and understanding that the automobile didn't have a title. And I made sure that was up front and told to her. No, this does not have title to it. But the BMW was immaculate for the year. It was a 2000. It had 300 something thousand miles on it, but she ran like a kitten. And she bought out a mechanic, she bought out all the people to come look at it, and they told her, for as old as this car is and as modern as it is, because this car for its age, 2000, had technology in it that had not been seen in cars of that age. This BMW was immaculate. It was an X5 2000. It was the I can't even remember right now, but if you go on my deal, you'll see pictures of it. I do have pictures of the car there, and it's a small SUV crossover. Very beautiful car, immaculate. But anyway, another story, another time. So the title is not required when sold to another private owner. Private owners only need a notary bill of sale for proof of ownership of an automobile. Okay, so basically what's just been said is you don't need a title to prove that you own the automobile. All you need is a bill of sale to prove that you own an automobile. You know, and that's true. You know, all you need is a bill of sale. You know, the police want to take it to an extreme. Well, do you have the title? That's none of your business whether I have the title or not. You know, it's none of your business. As long as I possess one of these right here, vehicle bill of sale, that's all you need to be concerned about. And honestly, to be honest, you don't even need to be concerned about that. Being that I'm a private individual, that's my automobile, has nothing to do with you or your jurisdiction in the first place. You know what I'm saying? But that just helps resolve legalities should they arise. You have a bill of sale for an automobile. You see. Now, unfortunately, if you are one of the more fortunate ones who gets financed and you are making payments and all that, well then unfortunately the private side's not for you where that's concerned, because of the simple fact you're required to meet such standards. You have to have a certain amount of insurance on the automobile, you have to have a particular bank, you have to have the driver's license, etc., etc. So unfortunately that won't apply. Now, that bill of sale that I just showed you is in reference to an automobile that I just bought outright. So basically what I do is I refuse to finance. I refuse to go through a bank. I refuse to do any of that. I just go through a private seller. And we go ahead and work out our deals between ourselves, because of the simple fact is I don't have to cross over into corporate United States jurisdiction in the purchase of that automobile, especially when the automobile is going to be mine, such as mine. I own mine. So, there is no payments, there is no obligation to the corporation, period. None. So a bill of sale is a release of ownership of seller and receipt to the buyer to prove new ownership. The purpose of the streets is for private purposes. So if a vehicle is used for commercial purpose on public property, it must be registered, and this is the only purpose of a title. The only reason why you would need a title, to register your commercially used vehicle. And that's what a lot of people don't understand. The DMV is a commercial entity. Anything and everything dealing with it is commercial. And you can sit there until you're blue in the face and try to argue, well, they have non-commercial driver's license. No, they do not. No, they do not. Supreme Court Justice Rehnquist has made it very clear in the case versus Reno versus Condon, okay, that everything dealing with the DMV is commercially related, period. Anything. There is no such thing as multiple driver's license. There is no such thing as different driver's license other than motorcycle. But even still, that motorcycle license is commercial because it's dealing in commerce. Anything that you register, anything that you put on a database becomes commercial under the Commerce Clause. That is also written in the Constitution. So before you go sitting there trying to bark up the wrong tree, make sure you understand and know what the Commerce Clause is, because that's the most important factor of everything being said to you, which you fail to understand. The Commerce Clause is in reference to commercial activity, and it is the only clause in relation to automobiles, motor vehicles, etc., etc., in the Constitution. Just saying. Just saying. So, the state is prohibited from violating substantive rights. Owens versus City, 445, U.S. It is well established law that the highways of the state are public property and their primary and preferred use is for private purposes. Stevenson versus Benford, 287. U.S. The use of the automobile as a necessary adjunct to the earning of a livelihood in modern life requires us, in the interest of realism, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. Barbarian versus Lucier, 139. Well, there you go. Automobile manufacturers provide a title as an approval to meet the DMV standards for commercial purposes. This does not mean that you are required to register your automobile as a private owner. There is nothing wrong with buying an automobile without a title from another private owner, so as long as it is used for private use. You only need a bill of sale for proof of ownership of the automobile. I just said that. I just told you that. And there it is in writing. Oh, and in case you're wondering what I'm reading from, I am reading from an Attorney General's bill that he wrote. Okay, just in case you're wondering. Using a title to register your private automobile as a commercial motor vehicle also means you are registering your home address as a place of business. Why do you keep thinking I keep telling you guys about never surrender your address? No jurisdiction. Sorry, I said that wrong. No residence, no jurisdiction. As long as you have established residence, the state has a security interest in your property, which gives them the ability to issue warrants to come on your property, tear up your property, impound your property, search your property. That's what gives them the jurisdiction, is the fact that you established some type of residency. And as long as you're allowing for the state to have a security interest by registering your property, okay, you gave them permission to do with their property, to do with your property, whatever they want. So the bottom line is do you give, if you own an automobile, you have to ask yourself, is this really my automobile? No. Now if it's registered with the state, it's not. And you gotta keep in mind, man, when you look at your driver's license, state ID, if you flip it over on the back, it does not say your property. It says the property of whatever state you're from. You know? So that's not yours. You're borrowing that. You're using it. You know, and eventually you're going to have to give it back. You know, whether you get too old to drive and you have to rescind your driver's license that way, and or you lose it, and or, you know, someone steals it. Choices. You know, so I mean, that's just how it works. But the bottom line is you don't own your driver's license. You don't own your ID card. You don't own it. It's not yours. It's the property of the state that you reside in. So, you know, when they made these laws in reference to voluntary registration. And that's something that the courts left out, but it's actually written in several places. You know, all registration of motor vehicles is voluntary. You can decide as to whether or not you want to register your automobile. That's your choice. Freedom of choice. First Amendment. The protection of the Fourth Amendment. Oh, anyway, but as I was telling you about the deal, you know, because I'm going to go back to it, because using a title to register your private automobile as a commercial motor vehicle also means you are registering your home address as a place of business. Your property is now registered as a business, allowing law enforcement more discretion to enter your property warrantless and take weapons off of business property if the weapons are not registered. These are what they call Catch-22 laws to violate your rights legally. The more contracts you have, the less rights you have. Given. The more contracts you have, the less rights you have. Because why? They turn them into privileges, you know? And that's what a lot of people are not understanding. The Supreme Court has classified the automobile. The Supreme Court has classified the automobile as a household effect. There is no case law that overturns that. There is no case law that supersedes that. So you can sit there and argue until you're blue in the face trying to convince me of one thing when I know what the law says. The law specifically states that a automobile is a household effect. Guaranteed. 100. The automobile is protected by the Fourth Amendment. Protected by the Fourth Amendment. Right to be secure and protected in that of your own personal property, papers, and effects. Oh my goodness. Well, well, well. Police have no authority to impound a private owner's property without a warrant. If the officer impounds, seizes your automobile without a warrant, it is considered stolen. Period. Auto theft. The protection of the Fourth Amendment extends to a person's effects, which include automobiles. Katie versus Dombrowski, 413 U.S. Straight from the Supreme Court, people. Carriages. Okay, and that's a 73 case. So this one goes back a little further. Carriages are properly classified as household effects. Actually, this doesn't even go back that far. Actually, I was thinking that it did, but the case that this case is referring to is actually older, but the case is actually new. Carriages are properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Arthur versus Morgan, 112 U.S. 495. A soldier's personal automobile is part of his household goods. Mulway versus the City of Chicago. A seizure conducted without a warrant is per se unreasonable under the Fourth Amendment. United States versus Hawkins. And that's a 2001 case. So there you go. So let's say you're pulled over. They say that they're going to impound your car because you don't have license, registration and all that. They impound your car. Unfortunately for that officer, not only is that theft, organized governmental theft, right? It's unreasonable because of the simple fact is registration of a motor vehicle is voluntary. That's a proven fact. So there's no way he can get around it. The impoundment is, after all, a seizure subject to constitutional limitations virtually identical to those governing a search. Brown versus State, and that's a 1995 case, 653 Northeast. The automobile is recognized as a pleasure vehicle. Another Supreme Court ruling. The automobile because see, the reason why I keep repeating this is so that you can get it in your head and deprogram what you've been told and understand what the law is saying. This is what an attorney general is citing from Supreme Court cases. An attorney general. The automobile is recognized as a pleasure vehicle, not a commercial vehicle. The distinction between the meaning is one is private use, the other is business use. Two forms of automobiles. Private automobile, business automobile. Two jurisdictions. Again, the word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. Liebrecht versus Crandall, 126 Northwest. And I'm sorry if I butchered that name on that case, but hey, I'm not German, so I don't know how to speak it. Statutes only apply to those with a contract. Statutes only apply to those with a contract. Law enforcement have no authority to arrest, and courts have no jurisdiction to prosecute a right that violates the Fourth Amendment. If you are arrested for driving without a license or registration, then you are considered kidnapped. Traffic infractions are not a crime. United States versus Johnson, 718. Traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public, and such traveler owed nothing more than due care to the public, and the owner owned no other duty to the public. Their automobile having equal rights to and on the roadways and highways as horse and wagons, etc. This same right is still substantive rule in that speeding, running stop signs, and traveling without license plates or registration are not a threat to public safety and thus are non-arrestable offenses. Christie versus Elliott. Now on that, I'm going to say yes and no to that, because I'm going to say yes to the no license plates, the registrations, and no license. I'm going to say yes to that. But I'm going to say no to speeding, running stop signs, because those are accidents waiting to happen. So I'm going to say that even though you are legally allowed to travel without a license, registration, plates, and all that, I would say that common sense, use common sense. Don't run stop signs. Don't go speeding. You know what I'm saying? Because 1 and 2, you got to remember, is you go speeding through a school zone, you run over someone's child. That could have been your child. You understand what I'm saying? So, I'm just gonna say, I'm gonna say yes, no to that. But even though that it's Supreme Court law, and you can argue that if you want to be that cold and about it, but I just don't feel that doing something like that would be, I would say practice safe driving at all costs. Regardless, whether you have a license or not, practice safe driving, people. I mean, it's only right, Even though the law even says that you don't owe the public nothing, in a way, yes you do. You do owe the public a little something. It's called consideration, if anything. We don't have to call it compassion. We don't have to call it any of that. But we will say that it's called consideration. So we would just keep it at that, because I feel, I'm out there and I'm doing it, and I always take into consideration the people around me. That's just how it is. So yeah, The Fourth Amendment, of course, applies to all seizures of the person, including seizures that involve only a brief detention, short of traditional arrests. All detentions, all detainments made by a police officer are considered custodial arrests. Okay? There is no such thing as being detained, not allowed to leave, as you're being detained for an investigation, as they try to detour the words. And I've told you guys before, they manipulate you by words, by thinking that if they tell you it this certain way that their script reads, that you're supposed to be okay with how they said it. No. All detainments at traffic stops are considered custodial arrests. You do have a right to have them read you your memorandum rights. Even though they say memorandum rights are no longer required, which is weird, because Arizona versus Miranda says differently. However, some state statutes now are saying that the police are not required to read you your rights. Yeah, I would say they are. And the reason why why the states have said that is because of the simple fact a lot of people go forth and utilize the Fifth Amendment against the police, which you can, because here's the thing. If an officer sits there and tells you you have the right to remain silent, and you do so, and then he arrests you because all of a sudden you are obstructing his investigation, whereas part of that memorandum says you have a right to not self-incriminate. Self-incrimination even involves you providing them with information and or physical evidence, but the courts say no. The courts say that it actually excludes physical evidence, which I disagree with that reading, because then that violates the incrimination clause altogether. Because if the cops utilize the fact that you don't give them a driver's license as obstructing justice or obstructing official investigation, by you pleading the fifth, then you just actually took a right and turned it into a criminal offense. Just saying. It's right there. I mean, that's the act that's been going on, and that's what's been being allowed, and for some reason that's not being addressed. If you're going to give an individual a Fifth Amendment right, you give them that right in whole, not in part. That the police power does not get to abuse their authority by manipulating words and utilizing half of that right that you are naturally given against you. Just saying. So anyway, if you're incarcerated and you're given bail, that's called a government corporate ransom demand. And for a crime to exist, there also must be an injured party. Which now, when you go, when you're being arrested, that you're being told that it's a criminal offense now all of a sudden. So the best thing to do is ask for a corpus delicti. Who's the injured party? There can be no sanction or penalty imposed upon one because of the exercise of a constitutional right. Shearer versus Cullen, 481. The selective prosecution, when referring to the decision to prosecute in retaliation for exercise of a constitutional rights, gives rise to the actionable right under the Constitution. Country of Kenosha versus CNS Management Inc., 223, Wisconsin. As a matter of fiduciary duty, judge or magistrate and any and all officers of the court are obligated to protect the rights of the citizens. In fact, the only reason government is in place is to protect the rights of the citizens, and for no other reason. To utilize the court for anything other than that is in fact treason. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. U.S. versus Will, 449 U.S. So there you go, and that's a 1980s case, y'all. Just in case you're wondering. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking oath to support it. Cooper versus Aaron, 358 U.S. So, okay, let's see. Racketeering. Racketeering is a law term that applies to an organized conspiracy to commit crimes of extortion or coercion. Do you see where this is going, people? Licensing, registration. Remember when I was telling you about the best and biggest organized crime syndicate in the world is the man-made government? And you guys don't even realize it? That you're being coerced, you're being extorted. You're being told that if you don't do this, you can get a ticket, you'll get a fine. That's extortion. Now, and if you don't believe me, do this. Go tell somebody that you're going to do something to them if they don't give you a certain X amount of money, and see what charge you get. Billy badasses. I mean, and that's for all you traders and trolls and haters out there. I'm telling y'all, go out there and tell somebody that if they don't give you a certain X amount of money, that you're going to do whatever, your choice of whatever deed you want to do to them, and see what you be charged with. So how is it legal for the state to sit there and say, if you don't license your motor vehicle and you drive on the streets, you can go to jail, or you have to pay this fine? How is that not the same? That's one and the same. It's extortion. It's hand in hand. It's all the exact same. It's just one, you have it on a organized level called government. Racketeering is the obtaining of money or property from another without his consent. induced by wrongful use of force or fear. Well, there you go. The fear which constitutes the legally necessary element in extortion is induced by oral or written threats. Traffic ticket. To do an unlawful injury to the property of the threatened person, impound your automobile. By means of explosives, fire, or otherwise, or to kill, kidnap, or injure him, arrest. Or a relative of his or her, or a relative of his or her family. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Oops, let me read that one more time because I think you guys missed it. No state shall convert a liberty, freedom, into a privilege, license it, and attach a fee to it. Murdoch versus Pennsylvania. So, there you have it. Liberty. Freedom. That's what liberty stands for you idiots that don't know, don't understand. You do have a right to freedom of movement. It's an inalienable right. Guaranteed. Now, again, what you dummies don't understand is the Constitution does not give you rights. It protects inherent rights. The freedom of movement is an inherent right. You inherited that from birth. You are given the right to move around wherever you want, whenever you want, however you want. You don't need a piece of paper called the Constitution to tell you that. However, that Constitution was drawn up to protect that right. You know, I have so many arguments of people on here always talking about, well, the Constitution says. I don't give a damn what the Constitution says. The Constitution didn't give you nothing. You're utilizing the Constitution in the wrong format. The Constitution is to be used to substantiate and support a right that you've already had. The Constitution does not afford you rights. It does not give you rights. It doesn't allow you to have these rights. It protects rights that you were born with. Okay? So let's get that part straight and clear. Okay? So once we have that clear and straight and you guys figured that out, maybe the rest of it will start falling into place. The Constitution does not give you rights. It protects your inherent rights. Inalienable rights. That cannot be deprived, regulated, stipulated, altered in any kind of way. Rights. Okay? So let's see. All requests made to the court are within the bounds of law and supports the fundamental purpose of any and all government entities and their obligations to the citizens. That the avertment defines such bounds for the court if the state, which includes the court, have established within their private capacity or in consort with some other association, establishment, agency, subcharter, or chapter, etc., some additional rules, regulations, statutes, and ordinances. They must act within the law and cannot abrogate the supreme law of the land and must follow the defines of Article 6. And they must acknowledge any and all supportive Supreme Court stare decisions. Which in fact and in law applies to them. In other words, if they're not in compliance with what the Supreme Court says, the state can be found liable. So there's that. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton versus Shelby County, 118 U.S. 425. Now, here you go. So, I'm not going to get off into the Federal Reserves and all that about the banking. We're going to hit that at another time. I want to kind of keep on the course of this because of so I'm actually that's gonna be another video all by itself. Yeah, we're gonna skip over that section because that gets into some of the executive orders that was issued down by John F. Kennedy and a few other presidents that issued some executive orders, and you know, and that right there. Like I said, that's going to get into a totally different avenue. Hitting with the IRS, the banks. Uh, so okay, so yeah, so and because that I'm looking at that and that with these executive orders that's in here. Talking about the gold and all that, what I'm saying. Me personally, I am not too, I'm not well versed on how that works. I mean, I understand the basics of it, what I'm saying. And I guess, like in all things, that's where one should start with the basics of things before they can actually start doing, getting involved in more fundamental and more complex things. However, in this aspect, it's like I told you, this is an educational thing. So I cannot actually speak on things that I'm not versed in. Because one, me personally, I don't grasp the concept of the banking industry because one, I don't use banks. I used to use banks a long time ago, and then I quit using them. So, for me, that topic is something that's like really there's a lot involved, and I'm not into the executive, legislative, administrative bullcrap that the politics of all that. I'm not into the politics of it. So, therefore, I'm not going to speak on that. So, anyway, forming of the DMV. Okay. First, we need to clarify, is driving a privilege or a right? This depends on whether you are driving for commercial use or private use. Commercial is a privilege, and private is a right. If the Constitution declares a right, the state can't take rights away to make privileges. Whoops. Those things which are considered as inalienable rights which all citizens possess cannot be licensed, since those acts are not held to be a privilege. City of Chicago versus Collins, 51 Northeast. What does the U.S. Constitution say about contracts? Under Article 1, Section 10, Paragraph 1, the U.S. Constitution clearly states, in part, no state shall pass any law impairing the obligations of contracts. Self-explanatory. I don't think the Constitution can make this any clearer that this is the loophole that all levels of government, commercial, corporates use to enslave freedoms. Now, what is the definition of a license? Okay. License in the law of contracts is a permission accorded by a competent authority conferring the right to do some act which without such authorization would be illegal or would be a trespass or a tort. Black's Law Dictionary, 2nd edition, 1910. And I do believe that definition is still the one that they refer to this day. I do believe, because I do believe it's actually cited in some brand new case laws right now, that is the actual definition that they still utilize. So as I've told you before, Black's Law dictionaries, a lot of people, well, that's outdated dictionary. No, there's no such thing as a Black's Law dictionary being outdated, a law dictionary that's outdated. They have additions for a reason. History is to be preserved, not destroyed. So if they've put it in writing, okay, and there's no mention that one dictionary supersedes the other or anything of that magnitude, then as in all things in life, you go back to basics. What I was just explaining to you about the the banking issue that I'm not going to get into. I know the basics, and that's where everything should start, with the basics, you know. So if you really want to get technical about this in definitions, you always go start back at the basics. Go back to the beginning. What was the original? Because that's still held law, and it's still a consideration that the courts have to look at. Because of the simple fact is, if the Supreme Court said that a license is this, and then all of a sudden somewhere down the decades the license definition changed, okay, the courts have the obligation, they are obligated to look to the law. And the law may have many different varieties of definitions and reasons, but they have to go back to the basics. Because if some definitions come in conflict with other issues and maybe can render a faulty decision, that's why they go back and refer back to older editions of Black's Law Dictionary. 90% of the courts today actually use the 6th edition of Black's Law Dictionary, which was, I think, dictionary that was written in the 50s, 60s, 70s, somewhere around there in those 3 decades. So, you know, you utilizing a 6th edition, you rely on the 6th edition, because one of the things that I've understood from a Supreme Court justice and just judges in general is that the 6th edition was one of the best expressed editions that Black's has ever published. You know, so there's that. You know, and that's a fact, not an opinion. That's a fact. That's what I was told. A license is merely a permit or privilege to do what otherwise would be unlawful, and is not a contract between the authority, federal, state, or municipal granting it, and the person to whom it is granted. American State Water Services Company of California versus Johnson, 88. If a contract can't be between a person and a government, how can a state impair contracts without violating the Constitution? And regulate corporations. What is the definition of a corporate? A large business or organization that under the law has the rights and duties of an individual and follows a specific purpose. A corporation is a legal entity that is separate and distinct from its owners. Corporations enjoy most of the rights and responsibilities that an individual possesses. That is, a corporation has the right to enter into contracts, loan and borrow money, sue and be sued, hire employees, own assets, and pay taxes. Therefore, the state granted the DMV to be formed as a corporate because the DMV is identified as an individual entity, private, and the DMV cannot be a government entity because it has the right to enter into contracts which violates the Constitution. The state has no power over the DMV's business for licensing, but the state can regulate the corporate's activities. Concerning the laws of the roads, DMV is registered as a corporate, and its contracting is limited only to the requirements of commercial activities. Persons faced with the unconstitutional licensing law, which purports to require a license as a prerequisite to exercise of right, may ignore the law and engage with impunity in exercise of such right. Shuttlesworth versus Birmingham, 394. So what is the DMV's specific purpose? To issue licenses, contracts to motor vehicles. How does USC Title 18 define motor vehicle? Found at paragraph 6. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highway. 18 U.S.C. Part 1, Chapter 2, Section 31, Definitions, Paragraph 6. So if a motor vehicle's purpose is to be used for commercial, how does USC Title 18 define commercial purpose? Paragraph 10, the term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. 18 U.S.C. Part 1, Chapter 2, Section 31, Definitions, Paragraph 10. According to U.S.C. Title 18, the DMV's only purpose is to license, contract, motor vehicles that are used for commercial purposes with the intent of doing business for profit upon the highways. Now, does the DMV law still apply to personal use? An action by the Department of Motor Vehicles, whether directly or through a court sitting administratively, as the hearing officer must be clearly defined in the statute before it has subject matter jurisdiction. Without such jurisdiction of the licensee, all acts of the agency by its employees, agents, hearing officers are null and void. As I've been telling you, no residence, no jurisdiction. And as I told you, and that's found in Doolin versus Carr 125 U.S. 618. That is actually the law. One of the case laws that I was telling you about the courts don't want you to know exists. That's one of the case laws where it's telling you about personal private automobiles. The state has no jurisdiction over it. The state has no jurisdiction over you, period, when it comes to the use of your private automobile. There it is right there in black and white. And this is coming from an attorney general who's putting this out there. So it's got to come from someone legit, right? But you know what? It's funny because you have all you trolls, you constitutional haters, traitors out there, and you haters out there who don't even know this. But you want to sit there and question what we say. But this is law, standing law, that an attorney general is telling you is the law. He just specifically stated in here, an action by Department of Motor Vehicles. This is the case law. This is coming straight from the law book. An action by Department of Motor Vehicles, whether directly or through a court sitting administratively, as the hearing officer, must be clearly defined in the statute before it has subject matter jurisdiction. No statute talks about private automobiles. The only private automobiles that's mentioned in a statute is a private automobile acting in commerce, such as a taxi cab, a Uber, a Lyft, anything that's doing commercial business. They do not mention anything about a private automobile for travel. And that's where a lot of you trolls, haters, and you guys are getting confused. The only thing it talks about in private automobiles in the statutes is those automobiles being used in commerce. So, get off your high horse, man. Get off your high horse. Of the agency by its employees, agents, hearing officers are null and void. Again, that case is Doolin, D-O-O-L-A-N, versus Carr, 125 U.S. 618. Right there. That's master. What the Supreme Court has declared is that the DMV must have jurisdiction of the licensee. And here's what that means for those of you that don't get it. Okay? If you're not registered with the DMV, you don't have a license with the DMV, and you don't hold a state ID with the DMV, they don't have jurisdiction over you. Period. You don't have to go and prove that, because their records in their computer is going to show that your name ain't in it. No automobiles registered in it. So therefore, they have no jurisdiction over you. Wah, wah, wah. Simple, people. Simple. You must have a contract to be within their jurisdiction, or their laws are null and void. And without jurisdiction, therefore, if a citizen is driving for personal use, the DMV laws do not apply. The Supreme Court also declared that only motor vehicle drivers are classified as an operator. not a person driving for personal use. The word operator shall not include, case law right here you go. The word operator shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. Shuttlesworth versus Birmingham, 394 U.S. Right there in black and white, people. You don't get no better than that. So when officers pull you over and they said, didn't I just witness you operating this motor vehicle? Nope. Shuttlesworth versus Birmingham says that I am not considered an operator traveling in that of my own personal private automobile. You know, and granted, you can't hold court on the side of the road, you know what I'm saying? But the bottom line is you film your interactions with the police and you keep track of everything. And when it's time to come to do your appeals, you know, or file your motions, these are the case laws that you put in those motions. Okay, so you know there's that. You know, I don't even know how to even make that any more clear. You know, that case law right there kind of says a lot. So I guess now the big question is it would appear that the state organized the use of the DMV as a deception to commit racketeering against private owners. Whoopsie. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Murdoch versus Penn, 319. And I told you, organized criminal entity, the government. Racketeering, extortion, the whole 9 yards. Through a driver's license. Wow. Now the big question is, does individuals traveling for personal use require a driver's license? It is clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of the business enterprise or adventure with the corporate state, no license is required of the natural individual traveling for personal business pleasure and transportation. Wingfield versus Fielder, 2D, California, 1972. There you have it. Supreme Court even says so. There you have it. No license is required. So, you know, again, to my haters and to you you guys that comes on there, especially you the new guy. I don't even know your name because it's not that important and it doesn't really matter to me who you are. But to you, the new guy who cited that Hendricks versus Maryland case, and I shut that shit down real quick because you're stupid and you don't even realize what the hell you're talking about. So here you have a case right here that just told you what you tried to say to me. It gave you the upside. But see, when you cited that Hendrick versus Maryland, or not the Hendrick versus Maryland case, I'm sorry, I apologize. You mentioned the Thompson versus Smith case, which you failed to actually mention the part in the case where it said that the only people required to have licensing was taxi cab drivers, chauffeurs, etc., etc. You forgot to mention that part. I meant to tell you that because I do have the case here. I've analyzed that case several times, and within that case, not only is it talking about in commerce, which obviously your dumbass doesn't realize or understand what the definition of commerce means. Okay? Commerce means to do business. That's what the courts have been talking about the whole time. Even though that police officer felt the need to revoke his license, he had no right to revoke his license. Now, maybe he did, you know, because I don't remember the actual deals about the case in general, but the one thing that stood out to me about the entire case was the fact that commerce kept coming up, one, and two, it said that this only applies to people in commerce. It actually says that in the case, so you might want to go back and reread that case before you sit there and call yourself trying to point out certain things to me on cases, because that's one thing I do. You'll sit there and put a case out there, I'll go get that case and I'll sit down and I will read to you the parts of the case that you did not want to see, because you're so stuck and programmed into believing what you believe that you pull out certain extracts of the case thinking that that's the law. It's not the law. That's just what fit your agenda. The actual overall law says commerce, and who is and who is not required to have license. That's actually in that case. So you might want to go back and read that. But this case that I just read to you, Wingfield versus Fielder, just told you no license is required for a traveler, private traveler. Whoopsie. There it is right there in writing. There you have it. A license relates to qualifications to engage in a profession. Thus, traveling without compensation with the corporate state means no license is required. What? Colorado court also confirms that the statute does not apply to citizens. What? Colorado Article 42.2.101 clearly states, licensing is for commercial drivers, not private citizens. What? For while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways as a place for private gain. For the latter purpose, private gain, no person has a vested right to use the highways of the state. That is a privilege which the state may grant or withhold at its discretion. State versus Johnson, 245p, 1073. Montana, 1926. Now that's what was wrote in that case that ended up in the Supreme Court. And I'm quite sure that statute's probably changed. However, it is law. Because nowhere in it and nowhere on it does it say that it's been superseded or overturned. So therefore, that's standing law. Imagine that. The DMV commercial corporate knows it is regulated by the state constitution and that their statutes only pertain specifically to their contractual limitations for regulating commercial motor vehicles. They know private owners are expressly exempted a license, registration, and insurance, so loopholes were created in the statutes as a deception to appear to include the private owner. Therefore, the DMV statutes are void because they are vague. If state officials construe a vague statute unconstitutionality, the citizen may take them at their word and act on the assumption that the statute is void. Wingfield versus Fielder, 2D, California. So here's a little note that was added, and keep in mind, people, this is from an attorney general writing this now. So he even says your job may require you to have a commercial license. It does not mean that you need to license and register your personal automobile. Well, okay, and again, like I said, this is coming from an attorney general, so I have to show you a conflict of interest here. Okay, because if you're trying to travel and live in that of the private side, but they're telling you that your job requires you to have an ID, you see what I'm saying? You're straddling the fence. You're in both jurisdictions. So the question is, are you going to be to the jurisdiction of the government? Or are you going to be to the jurisdiction of the private side? Because I would say, and this is just my opinion, it does not mean nothing neither here nor there, but in my opinion, I would go look for another job that wouldn't require me to have to step back over into that of the government side. See? I'd find me a job that would keep me in the private side, because I don't feel that a straddling of a fence to walk both worlds would be a positive There just can't be no positive thing that could come from that, because should you violate anything, you're automatically back in their jurisdiction. It pulls you right back in, and believe me, the way the laws are made and the way everything's set up, you'll be pulled back in before you even realize it. So my opinion would be to free and clear yourself of it, period. But again, like I said, that's my opinion. So police that acquire authority to enforce a license upon a non-bonded citizen thinking that they have it causes them to violate their oath by enforcing contracts upon that right. If officers know the laws governing their conduct, there would be less confrontation between law enforcement and a non-bonded citizen. When officers act on this deception, then they knowingly violate their oath. Article 6, your constitutional rights, Amendment the 4th, in violation of the U.S. Constitution, Article 1, Section 10, Paragraph 1, qualified immunity defense fails if public officer violates clearly established right because a reasonably competent official should know the law governing his conduct. Jones versus Contz. 7. Federal 3rd, 1359, 8th Circuit, 1993. Now what in the world would an attorney general be doing sending out information like this for? Or publishing information like this for? Now, keep in mind, not all law enforcement officers are out to get you. Many times a rational officer has allowed you to proceed without issuing tickets. So basically what that's on is censorship and the way you carry yourself, conduct. Because you got to remember what I told you, the loophole, discretion. One of the words, So one of the words that is out there is discretion, So, oh crap, I didn't realize this has got that long that fast. So, I'm going to go ahead and shut it down right there. Part 3 is now in the books. And again, I want to remind everybody that this is not me giving you legal advice. Okay? This is educational purposes only. What you do with the advice you hear is strictly up to you. Use at your own discretion, but rest assured that it is factual law that you are being read straight from law books, not from YouTube or online. These are straight from the law books. As I said, this what I am reading to you is straight from an attorney general. It was a brief that he used to argue whatever it was he was arguing, whatever the case actual was. It doesn't actually go into the actual case that this brief is found on, but I'm quite sure that if I looked it up and actually took the time to actually look at the case, I would find it. But I'm not interested in that case because my interest lies as to what the opinions were said. That's because that's what matters, is what the opinion said, because the opinion is the law. So I don't care what the case was about, obviously it was in reference to something with driving and some other things, because this covers a vast variety of things, and a lot of it I'm skipping through because he'll go off into a subject matter, and then he'll change it to another subject matter, and then bring it back to this subject matter and tying it all together, which is what they do. They're pretty good at. So basically what I'm doing is I'm going around a lot of the subject matter, because of the fact of the matter is I'm not trying to get into all of the fundamentals of how they tied everything together. Because, like I said, I'm sharing with you, but I'm not sharing everything with you. if that makes sense. A teacher teaches his students, but the teacher never teaches the students more than what the teacher knows. So it's up to you to take what I give you and do your own investigation and do your own homework. I gave you the foundation. Hell, I even built the walls for you. All you got to do is put the roof on, furnish the furniture, and you're ready to go. Okay? And you know, as you may have noticed on my channels, nowhere have I asked anybody for money. Nowhere have I asked anybody for donations. Nowhere have I said, you know, this or this is going to happen if you do this or anything like that, because I'm not about all that. You know, if you decide that you want to do something to that magnitude and do something, you know, then leave a comment and tell me, and then, you know, I'll get with you and we can arrange something like that. But do I want it? No, not really. I don't need it. You know, I don't expect it. You know, but, you know, on the same strength, like I said, you know, I'm not here about trying to make monetary gain. That's my channel's not even set up for that. You know, even though I can do live streams on YouTube, they was so nice to allow me to actually do live streams, which they didn't before when I very first started. So apparently I beat some kind of criteria that they required in their deal, and I shattered it by like record deals with, like, I think I scored 900%, which I'm not even sure how their analytics scores that. But apparently 900% is like 100% excellent to YouTube. So they felt that the videos that I've been producing scored enough views over that short little period of time that they said, you know what, we're going to go ahead and lift all restrictions. So I don't have any restrictions, you know. However, on the same strength, I'm not utilizing their platform to the fullest that I actually can. I can use it to the fullest, but I don't. I sit here on my regular camera, my webcam, and I film, record, and then I take and download it, and I don't even edit it. I'm not even editing. I'm not doing any of that. I'm not adding any special effects or anything like that. I can, you know, but I don't. You know, I'm not here to sugarcoat nothing with you guys, especially you knuckleheads who think you know everything and know nothing. Can't never provide any proof. Have nothing. All you have is what you say, and that's it. You provide case law that you haven't even figured out yet. That every single case that you even keep referring to that relates back to the past on this subject matter is in relation to commercial, and none of you figured it out yet. And it's so funny to sit here and listen to you guys quote these cases that we're quoting, but we're in the know that all these cases are in fact commercial, and you dummies ain't realized that. I mean, it doesn't take a genius to realize that the word commerce means to operate a business. And every single case that you've ever seen established by the Supreme Court, that's exactly what they're talking about. And I just read to you today, proven that the courts don't have jurisdiction over private travel. The Supreme Court said so, told them so. And in the case right here, as a matter of fact, let me go back and reiterate that for you, because I want to make sure that you know and understand that. The Supreme Court made it very clear. It is clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of the business enterprise or adventure with the corporate state, no license is required of the natural individual traveling for personal, business, pleasure, and transportation. Wingfield versus Fielder, 1972. Okay? They're letting you know, no license is required. But before that, the Supreme Court said this. the word operator shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. Shuttlesworth versus Birmingham, 394. And that's a 1969 case. 69 case. Okay? So then we go back to the other major case, the one that actually puts it all into perspective. I'm looking for the, hang on. Well, I thought I marked it. Anyway, the one case that I was actually referring to is the case about the jurisdiction of the courts that tells you that the court has no jurisdiction over that of a private individual. You know? And I don't understand why I'm not seeing it, but the courts made it very clear. You know? And for some reason I'm not finding it. I think I'm pretty close to it. Let me see. I thought I marked it. I could have swore I marked it. Well, heck. Huh. Funny. Federal Reserve. It's down at the bottom somewhere. On one of his bills here. But I do remember I marked it. But either way, in the forming of the DMV, oh, nope, that's not. They have, oh, here it is. I did mark it and I did not mark it. So let me mark it now. I marked it, but I went right past it. I read underneath it. So here you go right here. Here it is right here, y'all. Here it is right here. So this is the main one right here. And you can look this case up too. An action by Department of Motor Vehicles, whether directly or through a court sitting administratively, as the hearing officer must be clearly defined in the statute before it has subject matter or jurisdiction. Without such jurisdiction of the licensee, all acts of the agency by its employees, agents, hearing officers are null and void. Doolin versus Carr, 125 U.S. 618. Doolin, D-O-O-L-A-N versus Carr, C-A-R-R. Okay, 125 U.S. 618. There you go. That's all the case law you need right there. If your automobile's not registered and it's not in the DMV and you don't hold a license with the DMV, or you are not considered to be in their jurisdiction, therefore, they cannot take any action against you, period. Where no jurisdiction exists, no law can be enforced, period. Been telling you that from day one. No statute written, no policy written, no law can be enforced. No jurisdiction exists. Period. Right there. Attorney General telling you this. Period. Know the difference between contractual side and private side, people. This is Dark Angel. Part 3 in the books. Part 4 coming soon. We'll talk again. Have a good evening. I hope everybody's doing okay. And y'all, safe travels, everyone. That's running up what we're running up. And deuces.